How are you this morning?
Good.
It was the same. It was the same. It was just the face instead of the. I asked everybody how they were doing, and I got living the dream and just peachy, and I got the long pause and the eye roll and the okay. So I think everyone's on the same page.
I aim low. I woke up, so.
You're here. We're here.
I'm like, all right, moral victory.
That's funny. Maybe I'll test it out on them. Good morning.
Good morning.
How's everyone this morning? We've got a little joke going on in here because I've gotten just peachy and living the dream and maybe a couple of eye rolls about how we're all doing. So anyway, good morning. Let the record reflect state's attorneys present, defendant and defense counsel are present. Mr. Wilkerson, you were up, correct?
Yes, Your Honor.
You may proceed.
Thank you, Judge. Detective, I need to clarify one thing for the record. So, were there two separate devices that, of Justin Berry's, the distractions were attempted on? Okay, so, and one was successful and the other one was unsuccessful?
That's correct. One of them was a limited ability to search. I'm not sure why.
Okay. So, yesterday we talked about the fact that Brandon Dodd is also indicted in this case. Do you have any direct evidence linking him to the residence of Ronald Barnes?
When I have the evidence that I do have is that they got into the car, they drove together, they got to the location together. Mr. Johnson even said they got to the same area together, got out together in front of the house, and basically put them there. And when I spoke with Mr. Dodd, he said all they did was drive around, and they never went there.
So I would object to the hearsay portion of that, but you said in front of the house. So you're suggesting that a vehicle was parked in front of the house?
I'm going off of the suggestion that was made to me.
Okay, but the surveillance video showed two people walking down the street and
Right.
going into the driveway, correct?
Right.
All right, so aside from the statement of the defendant, nothing else puts him in that area that evening, correct?
At this time, definitively, not completely.
Now, with regard, I guess I need to wait to ask about the, and so, with regard to the shooting or the death of Ronald Barnes, is it possible that whomever was in that house that night could have been defending themselves when there was a shot taken or shot made?
Possible.
And does the fact that there was PCP involved elevate that risk or possibility that the decedent could have become violent towards someone?
That the decedent was violent towards somebody on PCP, and that other individual was defending themselves for you. Is that correct?
So, sort of, except if it was the decedent who had a PCP.
That's what I'm saying.
Right.
Okay, yeah, that's all.
That's what it is.
Thank you, Mr. Coleman.
Detective Crumwich, just a couple of, or maybe 3 or 4 follow-up questions. Let's talk about the phone data and the phone records from the defendant's phone. You've had an opportunity to analyze those phone records, and how would you characterize the data leading up to September the 14th of 2024?
So the data from the phone itself,
Yeah, all the location data,
Yeah, well,
the connectivity data, the communications,
Okay.
Leading up to
The phone,
September 14th.
yeah, if you look at the phone appears to have no trace of like any movement whatsoever. It's as if it was either turned off or on airplane mode or something. It just stops.
Stops when?
One, I believe it was the 13th. I cannot completely remember that day.
Well, let me ask you this. Was there any location data, connectivity data for the day of the offense, September 14th?
Yes, so there was some, from the other side, from the Google side.
Not from the Google side, on the actual physical phone from the gallery. Was there any connectivity data, anything from September 14th?
Oh, no.
Was there connectivity data, location data, other activity in the days prior to September 14th?
Yes.
You find that suspicious?
Very.
Now, you and Detective Wilson, after interviewing the defendant, you went out to the Heritage Inn, correct?
Yes.
And did you attempt to locate the black bag that the defendant said contained his clothes?
Yes.
Were you unsuccessful?
Oh, yeah, we're on success.
Did you locate a blue bag with his clothes?
No, sir.
Did you locate a Chanel bag with his clothes?
No, sir.
Steve Madden bag with his clothes?
No, sir.
Did you locate a duffel bag with his clothes?
No, sir.
Did you locate a handbag with his clothes?
No.
Just to be clear, the defendant himself put him on Ive Street between the hours of, either on or near Ive Street between the hours of 2 a.m. and 3 a.m. on the day of the offense, September the 14th, 2024, correct?
Correct.
In fact, during the recorded interview, he himself said, "We passed by Ives, I jumped out, yeah, we got out." Isn't that true? And lastly, I want to ask you about the term, it's commonly used, the term of drug rip. What is your understanding based on your training and experience what a drug rip is?
Well, prior to this, I was a narcotics detective, undercover, and we would see a lot of drug rips. Essentially, in a neighborhood, everybody knows where the drug houses are sometimes in bad neighborhoods. They all know, hey, that's the guy that deals drugs. He's obviously not gonna get the money and throw it into a bank account. He's gonna keep the cash because they take cash to buy more product and then build up that way. So they usually always have cash on them. And sometimes guys will go to that location to rip that person.
Or rob. You say rip, but you mean rob.
To rob, basically. That's what we call it, rip, and to rob them, take them of their funds for the reason that they'll have cash, and 2, they're less likely to call the police because they stole my money and my drugs. Nobody's gonna call us and say that.
All right, I said that was my last question, but you know attorneys. I do have one other question, maybe 2. But this question, I leave my little fancy handwritten chart here. Back to the Google location data. Again, these devices that are seeking to connect to a cell phone that may be either turned off or in airplane mode. What is your understanding of what happens with that Google data that is seeking to connect with a phone, but unable to connect to a phone until such time as that phone is either turned back on or taken off of airplane mode?
Yeah, so it kind of made me think, and I was looking at it, and then so I started researching through Google, and I started talking to professionals at this, especially Mr. Quartz, Detective Quartz, and everything like that. So
Detective Quartz, who has testified.
Detective John Quartz, who
in this
testified
case.
here, the mouth issue, yeah. And basically the way it was explained to me is when you go in airplane mode, it will still digitally check hands, and it'll still get all this information. It's just, when you take it out of airplane mode, it will register the times, like, so the times that you turned it on. So if you got on a plane at 10 o'clock and, that was one of your last interactions, you put on airplane mode, and you happen to pass by some of those other things and it's when they're in the airplane, once it lands at 12 o'clock, say noon, I guess, and you turn off airplane mode, it'll start uploading all that stuff with that time data in order.
So, in other words, applying that concept to our case, here the I Street column you got is actually the Google, so I'll just put that here. Is the Google location data. And would it make sense then, if that's the case, that when the defendant is at between 221 and 242 under our theory of the case, is at the I Street location with either the phone turned off or with the location data or the location function disabled, that when he leaves I Street, turns back on the phone or enables the data location system, that when the Google updates
Correct.
from those devices trying to connect to it, that the lag time will show a later time. In this case, the 258 being across the street, 258 being near the house, 304 moving away, doesn't necessarily reflect when it truly happened. Is that
Correct, it's just the time uploaded, and shared data between the phone and Google.
It's a lag time, it's fair to say.
Yes.
That would explain it.
No, not pass it.
Thank you, Mr. Coleman. Anything else, Mr. Wilkerson?
Just a couple follow-ups for now. So, when you talk about a lag time in the Google location services, the fact that, so if this theory that the phone was somehow turned off or put into airplane mode at some point, and then later that mode was turned off or location services were turned back on, that location data, though, would still show if that device is digitally handshaking with towers and the like, as you're suggesting, and Wi-Fi equipment, things of that nature. That would still show, for instance, if the defendant were at Heritage Inn at 2:50 in the morning, his phone, once it was turned back on, would show that location for 2:50 in the morning, correct? Yeah. So that theory still doesn't explain how that location data, right, could actually place this defendant at that Ive Street address while that car was seen driving around and while this defendant was at the Heritage Inn, correct?
No, that's not accurate.
Which aspect of it is inaccurate?
The geofence.
The geofence. How is that? How
It's
is?
outside, Heritage Inn's outside the geofence, so it wouldn't read that.
Okay, but what I'm getting to, right? So it wouldn't. You didn't get location services for his phone specifically, and you didn't have a geofence.
Objection, Judge, that's a misrepresentation.
I mean, the
It
testimony.
may be in doubt as to, or a question for this jury to decide if that data is from his phone, but to make a definitive statement like that is a mischaracterization that it's not from his phone.
Sustained, just phrase your question.
Okay.
We're not saying it is or it isn't.
That's my point.
Alright, so if the defendant's phone was at Heritage Inn at 2:50, it would not still show being at the Ive Street address at 2:50, right?
From what I was advised, and I think I've been people who are more knowledgeable about this, definitely, especially if it takes, of course, it takes agreement, is that it would just.
Look, may I stop you for just a second? So what you're about to say then is based on discussions you had and not based on your experience or training?
I agree.
Okay, then I'll withdraw that question. Was, when Mr. Johnson went in to interview, that was about 11 o'clock in the morning, correct?
Thereabouts.
On September the 14th, correct?
Correct.
And Mr. Johnson's the one who called Beaumont Police Department, right?
I believe so, yes.
Yeah, and that was because he had seen, or somebody had told him they had seen, that he was listed as a person of interest in conjunction with this death. Is that accurate?
That was the statement, yeah.
So he wasn't arrested and brought in. He came in voluntarily to provide his statement, right?
Yes, correct.
All right. And so when he was there, was a DNA swab performed?
Yes.
And what items were tested for DNA as far as items from the Barnes residence?
That would be the crime lab part, and I'm not sure what they did for it.
Okay, is it accurate that there was no DNA evidence that linked this defendant to that scene?
None of that was brought to my attention. No DNA.
None in any report that you've reviewed in the course of your
I know
investigation?
they knew that the blood was, of course, the obvious blood was Mr. Barnes, the decedent.
And was a gunshot residue test performed on the defendant?
No, it was outside of the scope of time.
Okay, what do you mean by that?
So usually, I think we get 4 hours to be able to do that. And from the time to the time, they had to wait well past.
So if someone has been out all night and goes back to the motel that they're staying in and takes a shower, would it make sense that they would change clothing? Yeah. And going back to this phone data, when your phone is put in airplane mode, that is an event that is logged in that phone's history. Is that accurate?
I'm not completely accurate. I'm not sure about that.
So, is it accurate to say that every few seconds that your phone is on, data is being generated by its operation, from well-being applications to calls to text messages to what applications you might use?
Yes.
Okay, and one of those things that are kept in that data are event logs, right? As far as if the phone's turned on or off.
Yes.
Okay. And so, in this particular case, an extraction was done on the defendant's cell phone. Did you see any event noted in the event logs with regard to turning the phone off or back?
I do not recall seeing anything.
And do you recall seeing anything in the event logs that indicates that the phone was placed into airplane mode?
Do not recall.
And so, with regard to, let me circle back to that just one more time. So, while the location data ceased at September 13th, other events still took place on that phone going all the way up until, I believe, the 18th, correct?
I believe so.
And so the phone data itself shows that that phone was continued to be used, right?
Correct.
Are you personally aware with the area that this took place in, that Ive Street area?
Yes.
Are you aware of, I guess, for lack of a better descriptor, a gambling shack on Primrose?
Yes, I am.
And in fact, that is where the defendant told you he was that evening, correct?
It did say that.
And it's not like he was just saying that he was somewhere. I mean, this is a place that you're actually familiar with, right?
Yes, sir.
So it does exist, and presumably you would have to know what it was in order to know that it existed, right?
Yes.
Last witness.
Thank you. Mr. Coleman?
Yes, ma'am. Detective Carmouche, the phone continued to be used. We don't dispute that. You don't dispute that, do you?
Yes.
However, all of the location data or anything having to do with where that phone was located was gone, correct?
From the phone.
Defense counsel asked you questions about whether or not a gambling shack existed on Primrose, and if that was where the defendant said that he was that evening or early morning. But nevertheless, during the interview, he lied at least on 2 occasions. One about the description of the vehicle he was in, correct?
Correct.
He also lied about whether or not he possessed a gun, correct?
Correct.
So is it also possible he's lying about being at that gambling shack?
Yes, sir.
That's the call.
Is it also possible that he's telling the truth about being at the gambling shack?
Yes, but he's also said he never got out.
The defendant or Brandon Dodd said that he never got out? Because I thought your testimony was that you said Brandon Dodd had talked about they were driving around that night and never stopped. Okay.
In the interview.
Okay. Would you agree that erasing data from a cell phone and that data actually being gone is a very difficult task?
I'm not implying anything was erased, but yes, that's way beyond me, definitely.
Okay. So, just to be clear, as you were asked about location data after September 13th, you're not suggesting that the defendant deleted that data, then, I believe was what you just said, right?
No, I was advising that there was no data generated.
Pass the witness.
Judge, may I republish a small portion of
Yes.
State's 53?
Sure.
Detective, I just want to clear up something about what exactly the defendant said about being on or near I Street and what his actions were. This is the benefit of having a recorded interview.
I looked up, he veered off, you know what I mean? Like he turned. But I said, well, what you want, brother? He said, oh, I'm finna stop the hill, man, bro. Like, I'm gonna kill someone else. I said, all right, all right, all right. We stopped. Oh, yeah, we go. We come back in. We burns off.
What street are y'all on at this point?
We're going down. So when I look back, I said, what street we on, brother? He said, oh, we just passed by the house, bro. I came from stay out here. I said, okay.
Pass by eyes?
Yeah, the I street, the one running down there one. He turned down, he put down here, posted his thing. I said, okay, all right. And he went back to, he jumps back in. He was like, man, where we going? I said, well, right here on Front Rose. You know what I mean? He takes his loop, and we go to Front Rose. Now, when we get to Front Rose, I said, well, we want to shoot. He was like, man, not really, brother. He was like, bro, pass through. So, you know, we just passed through. Chill. Smash back off. It was ain't up to us, you know. We smash back off and we go toward it. It's not forward.
So this is all between 2 and 3 o'clock?
This is all between, I want to say, yeah, between, if I had, you know, just taking a wild guess, I wouldn't really, you know, on the time, but I would say, right, probably to around there.
Okay. Do you see kind of the issue where, so between 2 and 3 o'clock, which is when this murder happened, you're putting yourself 1 block away on Primrose?
You know, put myself a couple of, oh, yeah, no. Yeah, because that's what the gallon is.
Did y'all stop at that house on Primrose?
Which one, the gallon saying?
Uh-huh.
Yeah, we took care of
You just passed by? Did you go stop and get out?
No, ma'am.
So y'all literally just, what was the point of riding by
No,
there?
he wasn't, I actually didn't want to shoot. He was like, man, I really don't, he was like, man, I don't think he was like, I really try again, but I said, bro, you ain't got to, man, I want to, I'm not sure.
Bro, I mean, at one point, did you and him go walking?
Yeah, to get to the, we got out.
Mm-hmm.
Yeah, we got out.
Got out of the car, went walking?
Yeah, we passed through.
We got out of the car and we went walking, correct? Correct. We passed by eyes, went to Primrose, we got out of the car, we started walking. How far away is Primrose Street from,
It's Primrose Street, then one more street, and then it's out street.
Pastor Williams Street?
Thank you. Mr. Wilkerson?
One last. Okay.
Don't say one last.
Okay. So, if Frank Broussard's testimony was taken as true, and there were 2 people who left the Barnes residence and got in that car and drove away, and those same 2 people came back, is it possible that at that time they left to dispose of a weapon or drugs or money or something of that nature?
Which testimony? The one that he gave, was that Gillen, or?
Actually, let's leave out the testimony part. If 2 people left the Barnes residence, and one of them was Donald Barnes, right? Because he said he left to go to his hearing, right? So, if 2 people actually left that residence, and then 5 minutes later came back, and those same 2 people were in the vehicle, is it possible that they left to dispose of a weapon or drugs or money?
It's possible. It's possible.
I have no further questions for Detective Parmushman, he be excused, Your Honor.
Any objection?
No, Your Honor.
Thank you, Detective. You're excused.
All right, this time the state of Texas rests.
All right, thank you, Mr. Coleman.
Approach, Your Honor.
Sure.
Just real quick.
Let's just take about a 15-minute break. It is 9:35. Please keep in mind all the instructions you were previously given. We will get started at 9:50. If everyone else would please remain seated in the courtroom, you are excused for about 15 minutes. All right, let the record reflect the jury's outside the presence of the courtroom. Mr. Wilkerson first, you had a motion. You can go ahead and do that.
Yes, Your Honor. I'm going to move for an instructed verdict of not guilty. The state has presented no direct evidence or even circumstantial evidence that actually ties the defendant to Donald Barnes' house on the evening in question. However, even if the state denies that request for an instructed verdict, there is an argument being presented here that that the law of parties may be applicable, and we would urge that there hasn't been evidence sufficient to indicate that Brandon Dodd was responsible for this murder on the night in question.
All right, I'm going to deny the motion on both of those. The reasons, I believe there has been sufficient evidence, at least for the matters to go to the jury. Anything else? Do you need a break before you do anything else?
Yes, Your Honor, just very briefly,
Yeah,
if I
sure.
could speak with Ms. Prazo and her client.
Yes, absolutely. We'll take a short break.
This courtroom exchange centers on a homicide investigation involving Ronald Barnes, with complex digital forensics and conflicting testimony forming the backbone of the dispute. The defense strategy focused heavily on reasonable doubt. Counsel highlighted the absence of direct physical evidence linking the defendant to the Barnes residence. No DNA evidence tied him to the scene. A gunshot residue test was not conducted within the 4-hour evidentiary window. Additionally, no personal items allegedly described by the defendant were recovered at the motel. The most contested issue involved cell phone data. Investigators testified that location data abruptly stopped prior to the murder time frame. The defense suggested the phone may have been placed in airplane mode, creating a lag in Google location uploads. According to that theory, later timestamps might reflect delayed syncing rather than real-time presence at the crime scene. The prosecution countered by emphasizing inconsistencies in the defendant's own recorded statements. During a voluntary interview, the defendant admitted being near I Street between 2 a.m. and 3 a.m., the window in which the murder occurred. He acknowledged getting out of the car and walking near Primrose, just 1 block away from the residence. Further undermining credibility, testimony established the defendant lied about the vehicle description and about possessing a firearm. The state also introduced the drug rip theory, arguing the location may have been targeted because drug houses often contain cash and victims are less likely to report robberies. After the state rested, defense counsel moved for an instructed verdict of not guilty, arguing insufficient direct or circumstantial evidence. Judge Raquel West denied the motion, stating there was sufficient evidence for the matter to proceed to the jury. Why this decision matters? A motion for instructed verdict is a critical threshold. If granted, the case ends immediately. By rejecting it, the judge determined that reasonable jurors could find guilt based on the evidence presented. The legal stakes are significant. If convicted of murder or under the law of parties, the defendant could face decades in prison. The ruling underscores judicial restraint. Credibility determinations and evidentiary weight belong to the jury. Now the outcome hinges not on speculation, but on whether jurors believe the digital trail and recorded admissions prove guilt beyond a reasonable doubt.